Greetings from Ann Arbor. Welcome to our annual estate planning workshop. This year's topic is navigating estate and charitable planning. I'm Sally Baker, Senior Director of Plan Giving for the University of Michigan. A couple of housekeeping items before we begin. We received a number of questions in advance, and our panelists will answer them during the last portion of the webinar. Questions can also be asked by using the Q&A feature at the bottom of your screen. They can be typed into the Q&A window at any time during the event. Live captioning is also available today. To view the captions, please click on Live Transcript at the bottom right of your screen and then choose Show Subtitle. I'm pleased to introduce our panelists. Mara Kent does estate planning, probate, and trust administration at Nichols, Sachs, Slank, Sendelbach, Buiteweg, and Solomon PC here in Ann Arbor. She and her husband are lifelong residents of Ann Arbor, or of University of Michigan, and the lifelong residents of Ann Arbor, and both graduates of the University of Michigan. Additionally, both sets of their parents are Michigan graduates. Their oldest daughter is a 2021 Michigan graduate, and their younger daughter is currently a junior at Michigan. Clearly, they bleed maize and blue. In addition to her practice, Mara is committed to community service. She's a board member of several area community organizations and volunteers her time and legal services to the Habitat for Humanity, the Washtenaw County Probate Court, Homes for Generations, and the Amazing Blue Crew, which provides support to University of Michigan students in quarantine or isolation housing. Terry Bertram is attorney and counselor at Legacy Law Center in Ann Arbor, where he provides estate and elder law planning services for families in the greater Washtenaw area and beyond. He moved to Ann Arbor to attend the University of Michigan, and he's been here ever since. Terry currently serves as the attorney for Pittsfield Seniors, which is the largest senior group in Washtenaw County. He previously was on the board of directors of an assisted living and nursing care facility and has acted as a planning commissioner at the township and county levels. Terry was also appointed by past Michigan governors to statewide task forces addressing disabilities and aging. Terry received his law degree from the Thomas M. Cooley Law School. Donna Snyder joined the University of Michigan's Office of Vice President and General Counsel in 1997 and is Associate General Counsel. Her practice focuses on charitable giving to the university. She assists fundraising professionals and others at the university with legal, tax, policy, and due diligence issues of charitable giving to the university. She also drafts agreements for major gifts, both current and planned. Donna received her law degree from the College of William and Mary Law School in Williamsburg, Virginia. And without further ado, I give you our panelists.
Thank you very much, Sally, and welcome everyone. As Sally mentioned, we received questions. We were so gratified to receive a lot of questions that many of you sent in, and sorry to contradict her a little bit, but we're actually going to try to answer those as we go along, rather than waiting until the Q&A. So we have tried to tune our presentation, if you will, today toward making sure we get as many questions answered as possible. Some of them were actually plan giving related for gifts to U of M, and so Sally's staff either will or maybe already has reached out to you to try to answer some of those. So let's start with Terry. Terry, would you give us an overview of how property passes at death?
So when I work with a family after someone has passed away, the first thing that I ask is how are the assets titled? Because that's going to drive the discussion further. One of the misnomers that people have is if I have a will or a trust, I don't need to worry about how my assets are titled. That's going to drive what occurs. And I have to tell folks that often neither one works if you haven't aligned how you title the actual asset with the type of document that you have. A will, for example, only is effective for telling the probate court what to do with any assets that are in the deceased person's name only. If they're held in a joint account, it goes to the joint holder of that account upon a first death. If it's a beneficiary designated account, it goes to the named beneficiary whoever you have designated on that custodial account. And by the way, if I may say, it's something that it's important that you want to update. I have seen in more than one instance that people have put beneficiaries on there a long time ago, and they haven't updated it. And subsequent to that, people have passed away, or that's not who they want it to go to. And afterwards, they'll come to us and they'll say, well, I already fixed it. I put in my will that it's supposed to go to so-and-so there, so can't you go to that life insurance company or that annuity carrier and tell them that what they've got is wrong? And I go, no, they're going to follow what is set there. So, it is important that you look at, does it have beneficiaries on it and contingent beneficiaries? And that's important for retirement plans, life insurance, annuities. And for other accounts, is it held in the individual's name? If you have a trust, I hope you have titled it in the name of your trust so that the trust then can say the who, what, where, and when. And other names that you can have on accounts, you can have what's called a POD or a TOD designation, which means pay on death or transfer on death. I typically don't recommend that you try to do estate planning by asset and trying to designate each asset going in different directions there, that you have a cohesive plan and have that drive how you then title the assets, and that tends to work better.
I think that's a great idea. So one of the questions was, how is property passing by the will affected by property passing by beneficiary designations or trust or something like that? So you've touched on that, but if you don't mind just
yeah. So the will first of all only drive those assets that are in the individual's name upon their death, and whatever the will says for those assets, that's what would occur. And if you have different assets with a beneficiary named on it, that's where those assets will go. If you have a combination of a trust with a will, which is very typical. In fact, I would never do a trust without a will. The will tends to be a very, very simple will, and we call it a pour-over will. The will says, if upon my death I left something in my name only, pour it over into the trust and handle it according to the terms of the trust. So you're naming the trust as a beneficiary for any uncaptured assets there. So in that instance, they can sing together, if you will.
I like that, sing together. So I think that answers a question that just popped up about, can't you have a trust be fulfilled at death so you don't need to title each asset in the name of the trust? You can title assets in the name of the trust, but as you said, you've got this pour over effect of the will. So
Right.
Assets would go to the trust.
Right.
Thank you. Mara, let's talk about what documents then should be completed during the estate planning process. Unmute.
Thank you, Donna. Sorry about that.
My job.
Yeah, so there are 5 main estate planning documents that I usually discuss with my clients, and then potentially a 6th category of documents. But the first 2 documents I always discuss with my clients are a durable power of attorney for financial decisions and a durable power of attorney for medical decisions. In some states, that durable power of attorney for medical decisions is known as an advance directive, as a living will. Michigan has a little bit of a different subset, if you will, of language, but they all are essentially dictating what should happen to you while you are alive if you need assistance or if you become incapacitated. So here in Michigan, we call the durable power of attorney for medical decisions a patient advocate designation. You're appointing somebody to make decisions for you in the event that you can no longer make decisions for yourself. And those oftentimes are end of life decisions like removing or withdrawing life support or organ and tissue donation, things like that. But it could also be if you're incapacitated and somebody who is making a decision, whether you enter into a nursing home or whether you're getting in-home care or something like that. Importantly, that document will prevent the need for having to have a guardianship over you. So it's a really important document. It's not very expensive. It's not very hard to create, but it's super powerful because then your loved ones don't have to petition the court in your county to have that guardianship. On the flip side, we have the durable power of attorney for financial decisions. And that document, we often recommend that you make it effective immediately as soon as you sign it. And COVID's a really good example of why you might want to do that. Let's say, for example, you get COVID and initially you are admitted to the hospital because you're having breathing difficulties. You may have capacity to make decisions, but you're trapped in the hospital and your loved ones can't come visit you on the COVID unit because of the spread of the disease. And so what do? Maybe we need to talk to your insurance company about extending your insurance benefits. Maybe we need to access your bank account or pay your bills, things like that. No one can do those things for you without having that power of attorney form. And one question I often get is, well, my spouse can handle all that. Not if they're not on the policy with you. Oftentimes they won't even talk to your employer, or the employer won't even talk to you about the health benefits without that power of attorney form. So those two documents, in my opinion, are extremely important. And that one prevents the need for having a conservatorship over you. So if you're following the Britney Spears story, for example, with those two documents, we could have avoided all of that court involvement and merely reporting to the court and the court appointing someone that the court thinks is best. You get to make those decisions for yourself. After you pass away, the next two documents that you're most likely going to be considering is the will that Terry just mentioned and the trust that we talked about as well. And as Terry discussed, the will is going to govern what we call probate assets. And those probate assets generally are assets that are owned in your individual name when you pass away, that do not have a beneficiary designation on them, that are not jointly owned with someone else, or do not have some other way through the law of your state to pass to your loved ones outside of the probate process. Importantly, also, if you have minor children, you're going to name a guardian and a conservator for your young children in that document as well. But a lot of people want to avoid probate. And so we already learned through Terry that you can avoid probate through beneficiary designations. You can avoid probate through certain kinds of deeds. And you can also avoid probate through creating a trust, so long as you're directing your assets into that trust. So as Terry mentioned, you could either retitle the assets in the name of the trust, or you could name the trust as the beneficiary of certain accounts so that it only goes into the trust on your death. But I tell clients, think of a trust as kind of like a safe. You purchase this safe, and the combination to the safe are the terms in that document. So if you want to make sure that your 15-year-old doesn't receive any money outright when they turn 18, you might say in the document, I'd like my trustee to pay for their health and their education through age 30, but they only get half of what's left over at 30 and then maybe half of what's left over at 35, or whatever terms you set on. So a trust is really helpful, but the most important part is making sure then that you get your assets into that trust. And that's the part that a lot of people, unfortunately, either haven't gotten the right advice from their attorney on, or maybe have tried to do it on their own, not realizing that the document itself is like an empty safe. If we don't put our valuables in the safe, it doesn't do us any good. And that's the same thing with the trust. And then the fifth document that I talk to clients about are deeds. Our real estate, we can't put a beneficiary designation, at least in Michigan, we can't put a beneficiary designation on our property. So in Michigan, we have certain kinds of deeds that will transfer the property to either beneficiaries or to your trust on your death. But in other states like Illinois, there's a beneficiary designation deed, or there are certain forms that you can fill out to make sure that that property will end up in the proper hands on your death and outside of probate. So those are the 5 main documents. And then the 6th category are all kinds of other trusts: special needs trust, retirement trust, charitable trust, and lots of other things that we'll probably hit on some of those today too with the charity piece of it. But there's a whole separate category of other things that may or may not come into play depending on your own estate.
Okay. Terry, would you mind, while we're talking about trust, talk about how one might choose a personal representative, and also, I'm going to put this one in here, what you consider are typical reasons for setting up a trust. Mara mentioned maybe probate avoidance, but maybe some other reasons that you might talk about.
Yeah. Well, let me answer that part first and go back then to who you might consider as a trustee or personal representative of your estate. In terms of the use of a trust is, one of the characteristics I say is people is if you have folks that you do indeed trust, so that you don't need the judge at the front of the court with a mallet and a black robe telling people what to do, that you've got a cohesive family and or system in place there, that's not necessary. So some families are so dysfunctional, they need that judge no matter what there is. But other reasons are, frankly, it's a cost benefit. It costs more to establish a trust, but it's less expensive typically in the long run in settling it. Whereas a will is less expensive to set up, but it's going to cost more for the beneficiaries at the end going through probate and what have you. So, I've had clients where we're helping out who have just had an income stream and they rely on their income and say, a will-based plan is sufficient for your circumstances, where others say, I want to make it real easy for my family upon my death, and people are scattered to different parts and not living in the area there, where a trust may make more sense. Additionally, if you're concerned about incapacity, the assets you put into a trust, you can name successor trustees to be able to manage those in times of incapacity. And perhaps if you're concerned about the cost of long-term care, that with a trustee, they can help you to not have to spend down all your assets and qualify for long-term care assistance from government resources sooner. And it's easier to work with a trust in that respect. As to who we might pick to be in charge when we're not of our estate or our trust there, let me tell you who I wouldn't deal with. If someone comes to me and say, well, I'm going to pick this child to be the one in charge, and the reason is they're the oldest child. And I'll go, well, that's not a good reason to put them on as being the person in charge, because it's not an easy task to do. One, I mean, you are trying to gather up assets, and you may have different types for retirement assets where there's significant income tax implications as to how you draw that out. You may have real estate, you've got other assets there. It takes a level of sophistication to do with it. And if you want to make sure that families don't get together at Thanksgiving after settling an estate at death, make sure there's someone there who's slow on doing the job, isn't transparent, and doesn't pay attention to detail. All characteristics that really are important for who's ever in charge, that they are transparent, that they do pay attention to detail, they communicate well with the beneficiaries, and they move the process along. As it is, it can take a while, and there are tax returns to be filed and making proper elections of that, but you want to know that you've got someone there that's competent in doing that. Now, the value of having family members serving as a trustee is, you know, they've got the family knowledge, they're going to be caring and empathetic to the beneficiaries and can be sensitive to that. But the other side is often they don't have a business savvy and or any experience in handling this. Whereas if you go to a corporate trustee, you know, they're professional, they're experienced, they've got a track record, they're regulated as to what they do. The negative of a corporate trustee is they're going to be dispassionate, often ignorant of family matters, and sometimes it can be hard to reach them in that you get a different person each time you interact with, you know, the trust department and that. And so, you know, one of the other methods that some folks go is a combination where they'll have an individual trustee along with a corporate trustee and sort of co-successors working as a team. And that can work. I mean, sometimes it can be clumsy depending on if there's a clarity as to the roles and the functions there. But sometimes that's a great alternative to it being one or the other.
Okay, and kind of while we're talking about this in general, either one of you, when would you start estate planning and when would you then, how often would you review it? So Laura, you wanna jump in?
Yeah, I'm happy to answer that one. I think as soon as you turn 18, every single person needs to have a durable power of attorney for finances and a durable power of attorney for medical decisions. And for any of you wondering, there's a really great article from 2015 that I refer my clients to from Forbes.com that says 2 documents every 18-year-old should have. That's because once you turn 18, your parents no longer have the right to make those decisions for you. We're seeing through COVID, even younger people needing assistance in making medical decisions or financial decisions if your student goes abroad. And then every major life event after that, if you're getting married, if you're buying a house, maybe you're going through a divorce, you're getting ready for retirement, or you're helping elderly parents. There is no wrong time to do an estate plan, but every step of the way throughout your lifetime, you should begin with an estate plan and continue updating it. That's my thought.
Terry, anything to add or?
Well, I would echo what Mara said. The only thing that sometimes I'll attempt to be a little funny with folks is say, as long as you can tell me before you'll become incapacitated or before death, make sure it's done before that. There, in regards, and you know, but to be serious, it's sort of like if you own your home outright, there's no requirement, because there's no mortgage lender, there's no requirement that you have a homeowner's insurance policy. But I will bet you that all of us will have a homeowner's insurance policy, whether we have a mortgage at the bank or not. And part of that is peace of mind. We don't hope to be able to use it. We hope we never have a claim in terms of there being a fire or flood or the roof blown off in there, but we want peace of mind. And the documents that Mara referred to there, I refer to it as the legal first aid kit that we all need to have in our possession. Is it gives us peace of mind. We don't know when it'll be needed or necessary, but we want it to be in place when that does occur, and we don't always get to choose.
And Mara, one of the questions that just popped up was, do you mind just repeating the 5? Mute.
I keep forgetting to unmute. Sorry about that. Yeah, the 5 main estate planning documents that I refer to with my clients are the durable power of attorney for financial decisions, durable power of attorney for medical decisions, the will, and then potentially a trust, and then a deed. Whatever state you're in Michigan, I would recommend a ladybird deed, but in other states, there are different kinds of deeds. So those are the 5 that I make sure that I discuss. That doesn't necessarily mean that everybody needs a trust, or people who don't own real estate are going to need a deed, but those are the typical ones that come up.
Someone is asking, if you have a durable power of attorney, then do you need a HIPAA document to speak with medical and insurance personnel?
The answer is yes. So for all of my durable powers of attorney for medical decisions, I also include a HIPAA release. For those who aren't familiar, HIPAA is the Health Insurance and Portability Act. Just because you granted someone the power to make end-of-life decisions doesn't satisfy the requirements under HIPAA for them to be able to talk to your doctors and look at your medical records. So if you want your patient advocate to make informed decisions, you're going to want to also sign a HIPAA release, and most attorneys are going to include a HIPAA release in that document so that you can pre-authorize, if you will, your patient advocate to make those decisions.
Thank you. So let's turn, Mara, while you're on, let's turn to some tax questions that we've been taking from folks. What steps should individuals take to be sure that their estate plans work as they intend, given the potential tax law changes? And in particular, are there matters that people should think about before the end of 2021, which is days away, unfortunately, but anyway.
Yeah, right. So do I only have a few minutes to talk? We can talk forever about this topic. Yeah, Donna knows this too, and I'm sure you all do too as well. But to understand really what might be coming down the pike in terms of taxes, you kind of need to understand where we're at right now. So right now, our estate tax limit is very high. It's $11.7 million in 2021 for an individual, and you double that for a married person. So you're looking at $23.4 million for a married couple before an estate tax would kick in. So there's not a large percentage, although there are a fair number of people that still might have a taxable estate. In addition, you also need to understand how gifting works. Right now we have a $15,000 gift exclusion amount. That's per recipient per person. So if you're a married couple and you want to donate to a particular person, you each could give $15,000 or $30,000 per year to that person and not have to file any tax return. One of the big misconceptions though is, oh, if I give any penny more than $15,000, now I've generated some sort of penalty, or the IRS is coming after me or something like that. And that's just not the case. And it relates to that estate tax limit. So if you're gifting more than the annual exclusion amount, you simply have to file a gift tax return. I believe it's 709. I'm not a tax professional. I think it's called 709 form. Yes. That you just report on that form how much above the $15,000 limit you have gifted to a person, and it goes towards your overall estate limit. So if you gift $1 million during your lifetime and you were to die this year with our limit being, 11.7 million, that $1 million that you filed would just reduce your overall estate tax to a remainder of $10.7 million. So there's not harm in gifting more. Gift away. Be happy with gifting. Just make sure that you're talking to your CPA so that the proper forms are filled out. So that then brings us to, well, what's going to change? And this really high tax limit, right now, we know for certain it has a sunset clause in it that says at the end of 2025, this is going to go back to the Obama era estate tax, which was about $5.6 million when he left office. But then it's going to be adjusted for inflation and cost of living. So we're guessing around 6 million-ish per person, double that for a married couple. But that just is something that we know is set unless Congress acts to do something differently. And if you're paying attention to what's going on or potentially going on over in Congress right now, they're talking about maybe pushing that up sooner. The bipartisan infrastructure deal did not touch the estate tax yet. So this would be part of what is being negotiated still with the Build Back Better program. And as we know, we're not getting a consensus on what to do with that. So whether anything is going to change before the end of this year or not is anyone's guess. But it does create wonderful opportunities if you're even concerned about it and you have maybe a taxable estate or definitely a taxable estate. go ahead and do some gifting, make some charitable donations. We're going to be talking about charities in a little bit and the tax advantages to doing that. There's certainly not going to be a harm in gifting, and doing that while you're alive is always, I think, personally satisfying.
Okay, and thank you for that segue, because charitable planning is where we want to turn to next. So Terry, when is a good time to start planning your charitable giving, and how do folks deal with the uncertainties of family needs in the market, but make sure they have assets reserved for their charitable planning?
Well, it's not a one size fits all, obviously. It's what is the motivation of the potential donor? I mean, I find that most of the folks that I interact with who are interested in doing something, the most important thing to them is they want to actually help the charity. And then if they can get tax benefits of it, that's also important too. So, I mean, what I'm asking them is are you able to give up control of this asset now? Or are you in a situation where you're wanting to give up some control, but want to keep some options there because there's different tools available for that? And in terms of the tax situation, what's more important? Are we looking for an income tax deduction now or an estate tax deduction later on? And so that those are different variables for folks to take into account. There is, the immediate impact of their charitable dollars going to work now versus it being a long-term objective, something that can be done later, as well as the tax issues and what have you there. And to give an example, if you will, because when you also mention the other part is, how do you do this when you've got different competing needs? Had a gentleman who was fairly well off, but he's got a couple of family members that he's responsible for taking care of. And so working with, actually in this instance, with folks at the University of Michigan, we were able to, because he had clear charitable intent and wanting to do some things in the hospital arena there, but while taking care of his family members should he pass away before them. And so with the help of the development staff there and Sally's good staff there, we came up with the idea of charitable gift annuities. And so upon his death, there's charitable gift annuities, which is a device that the balance will go to the university, but upon his death, should these loved ones still be around, they will get a monthly income for the rest of their life. And then the university will get the balance. So he was able to make sure he took care of his family, but also making sure his charitable intent was met too. And so that's just different scenarios that are available to us. Great.
Well, kind of while we're talking about that, do you want to just go ahead and mention another common life income plan, the charitable trusts, charitable remainder trust?
Certainly. So charitable remainder trust is, again, a device that where you can set aside a certain amount of money for a charity, but retain for yourself or someone else an income stream for their life or 20 years. And it's, again, a nice way of providing for various people needs now, if you will, and making sure at the end the charity receives it. And we're finding that, this is a tool too, now getting into with retirement plans where you have to distribute them to your adult beneficiaries over a 10-year period under the new Secure Act, but you say, I want my beneficiaries to have an income stream, but I don't want them to get it all in a short 10-year period. I want it stretched out. I mean, I have folks who say, nowadays, this generation doesn't have pension plans like we had. They're not necessarily saving for retirement. I want to provide an ongoing income stream. A charitable remainder trust may be a good device to consider, and to put in that a retirement plan where you're not being subject to the income taxes by cashing that out.
Thank you. So speaking of retirement plans, Mara, can you tell us kind of what the differences are in terms of using retirement plans for charitable purposes during life and after death? What the vehicles would be and the tax differences?
Sure. Yeah, retirement plans continue to be a really great vehicle for providing to charities. So during your lifetime, one of the things that people often do if they're charitably minded is to do what's called a qualified charitable distribution. And what's nice about that is you're doing a distribution from your retirement account during your lifetime to a charity. And because it's this qualified charitable distribution, you get the added benefit of doing this up to $100,000 per year, which is huge. As we just talked about, when you're donating to an individual, not a qualified charitable distribution, you're at that $15,000 limit. So here you've got this wonderful vehicle. In addition to that, it also is sort of getting rid of your requirement for taking out a required minimum distribution. So there are some people who are like, gosh, I don't really need to take out this required minimum distribution. I don't really want to add that to my income. And therefore you can instead do a qualified charitable distribution with that money where the income is not counting against you, and you're benefiting the charity during your lifetime, and you're also satisfying the required minimum distribution rules. So wow, win, win, win. And then a quadruple win there for the University of Michigan or whoever else your charity is that you're deciding to give that to. So a wonderful opportunity during your lifetime. The gift, because it's going to the charity, is not considered as income to you. And so it's a great opportunity. But there are people that are not really in that position where they maybe don't want to do that during their lifetime, or they're nervous. Oh, sorry, go ahead.
Let me interrupt. I just want to clarify that when you say there's no income to them, so there's no income taxation on this, right?
Sorry. Yeah.
And you don't get, and as well, you don't take a deduction. So there's, no, it's just a wash on
That's
tax,
right. Yeah. Sorry about that. Yeah, there's no income tax implication to you. And as you said, it comes out like a wash in that situation. And you're also benefiting the charity, and you're getting to see this gift in action while you're alive, which is really important to some people. But there are other people then that say, I'm a little bit nervous about this. I don't know if I want to give it during my lifetime, or I'm just not sure if I'm going to need nursing home care later, or what really is going to be the state of my finances down the road. And I would rather, if I'm going to leave something to a charity, consider maybe doing that through my estate. And that is also a wonderful option. I think we're very lucky to live in a country that really promotes charitable giving. And whether it's during your lifetime or after your death, there are advantages from either standpoint. So after you have died, the advantage to donating to a charity, particularly of a retirement account, is 100% of that gift goes to the charity, because charities are tax exempt organizations. So as a tax exempt organization, they aren't, the income is not taxed to them. So they get 100% of what you're giving to them. Whereas if you gave it to your son or your daughter, unless it's a Roth, they're going to be paying taxes on that particular account. So it's a wonderful vehicle after you have died to give 100% of that to the charity without having the income tax implications that you might otherwise have. Because even though we've talked about, the estate tax, you have to keep in mind that the estate tax is different than your income tax. So I often have clients that ask me, oh, because I'm below the estate tax limit, 11.7 or 23.4 million for a married couple, and I give my retirement to my son or daughter, they don't have to pay taxes on it, do they? And I said, well, hold on a second. They would if it's not a Roth, because all that retirement money that's non-Roth money has not yet been taxed. So they don't pay income tax on it, but they're paying the tax that was owed on that particular asset when inherited to them then as income. Whereas, again, to the charity, none of that has to happen. It just goes 100% to the charity. Now, the estate will still have to include that amount that was given to the charity in terms of the value of the assets, but it's going to be offset by a tax deduction as a charitable contribution. So talk with your tax professional about which option might be the best. And this is probably also a good idea to, if you're thinking about that, running this by your financial planner as well. Is it better for me to gift during my lifetime? Is it better for me to leave a gift afterwards? But the wonderful thing is you've got great options either way. And I think we're very blessed to have these wonderful opportunities, whether it's while we're alive or afterwards, to be able to do that.
So many opportunities. And don't keep yourself unmuted because I have a follow-up question.
Oh, okay.
And that's that someone had asked about who or what is the best designation for a Roth IRA and a regular IRA, specifically between, say, the university, which I think you've already answered in a way, but anyway, a young person or an older person, say over 70.
Okay. Well, so a lot of that answer is going to really depend on what are your goals, what are your desires. So, I can start off with telling you what is, in my opinion, the worst beneficiary designation for a retirement account. There's probably two. The very worst to me would be leaving it blank or saying my estate. Because if you're leaving it blank or you're naming my estate, this new law that passed last year called the Secure Act that governs how retirement assets are inherited says 5 years. If you're leaving it to an estate in which you have to liquidate that account. And then if it's a non-Roth, you're paying taxes on it. And or whoever the beneficiary is paying taxes on it. If it's a Roth, the taxes have already been paid. But again, the Secure Act would apply to both Roth and non-Roth. So you have 5 years if you're leaving it to a probate estate. The second worst one, if you will, to name is to name a minor as a beneficiary. I want to name my 12-year-old child as the beneficiary of my retirement account. No, don't ever, please don't ever name your children or your grandchildren who are still minors as beneficiaries of anything, but especially not of retirement accounts, because if you do, a minor cannot inherit while they're still a minor. You have to petition the probate court to get a conservator appointed. And then if it's not in a trust, they have until age 18 and then they can liquidate all of it. And so if you have a very sizable retirement account, most people aren't going to want their 18-year-olds or, inherit that $1 million or whatever it is right at age 18. You want to push that off a little bit later. So circling back to our options between, do I pick a charity like the University of Michigan? Do I pick somebody who's maybe over the age of 70, or do I pick a young person? Well, if you do it correctly, such as creating a retirement asset trust, a young person would be an option, because the Secure Act says if you put it into a special kind of a trust, not just a regular trust that we've talked about, but a particular kind that meets these IRS regulations, that young person can take out just a required minimum distribution until they're 18, or possibly all the way up to age 26 years old. And then they get 10 years after that in which to liquidate the account. So if it's set up properly, theoretically, that young person through a retirement trust might be able to hold that money, or the trustee would hold it for their benefit until they're age 36, potentially 10 years after 26 if they are in this specified course of education. And I did a little calculation for you. If you just take a $200,000 retirement account, and you put it into a retirement trust for a 5-year-old, okay, you've got a 5-year-old child, and they end up going to college and grad school and medical school or whatever, and they get out at age 26, and then they have 10 more years after that in which to liquidate it, that $200,000 account at 7% interest, no additional contributions, is over $1.6 million by the time that they're 36 years old. So you can see the growth benefit that can happen. So if you're looking for growth, a young person is a good option. If you're looking for tax benefits, a charity, hands down, is a fabulous option because, again, what we talked about before, they don't have to have that income tax on the inheritance, if you will, or on the gift, the charitable donation, because they're a tax-exempt organization. So charities are great avenues for retirement accounts. As to the older person, it depends on who the older person is. If it's your spouse, I call the spouse the most favored beneficiary. The spouse, as the most favored beneficiary, gets to take out just a required minimum distribution based on their life expectancy, or what's been termed as the ghost life expectancy of you who have died. They still give you a life expectancy even though you died, and whichever one's better, the spouse gets to stretch it out over that period of time. Now, in your hypothetical, Donna, you said, what if that person's over 70 years old? Well, so maybe then you're not going to get as much bang for your buck in terms of stretching it out as if you would if you had a spouse who was much younger. But if I were to just, from a tax standpoint, say which one's the best, I would say charities. If I were saying from a growth perspective, which one is the best, maybe a retirement trust for a young child. But the Secure Act, by the way, only lets you do that special retirement account if your own child, not for a grandchild, not for a niece or nephew who's a minor, only the account holder's own child. So if you don't have that option, a spouse is another great option. So you've got some really great options, but you also have some that you want to kind of avoid.
Okay, thank you. So Terry, actually, I had one question here that I just want to clarify. This is from the question about the income from a charitable remainder trust is good for a maximum of 20 years. So Terry was talking about a term of years charitable remainder trust. There are certainly you can do a charitable remainder trust for life of individuals, life or lives of your beneficiaries. So yeah, there's, I guess, two types in that respect. There's
Right.
for life or lives, or for a term of years up to 20 years, but not all of them are limited. So
Right.
anyway, so let's talk about donor advised funds. We've had some questions about donor advised funds and how making a lot of people have donor advised funds. So would you compare using a donor advised fund to making a gift directly to your chosen charity, and how that might work out, especially in terms of if you throw in, I mean, lifetime, but as well as, what happens after death?
Okay. So a donor advised fund, I think I saw somewhere where someone referred to it as like a charitable savings account. It's where you can put in a lot of money or however much, and then you are advising that fund on giving it to charities either on a regular basis or after a certain period of time or event of your death there, that it goes to them. And it can be very flexible. Now, there are some restrictions. You can't pull out of the donor advisor fund after it's been created. It's irrevocable in that sense. And it has to go directly to the charities for charitable use. So someone asked me, well, could I use this to pay for my premium seats at U of M for the season tickets for football and basketball? And the answer is no. It's not for that purpose, nor can you pay for an event that you wish to attend that's got even charitable intent with it. But you could give to the university for a specific purpose. You can give to other community charitable entities in that respect. And so it gives you a lot of flexibility in terms of putting the money aside now, but deciding later on how and when and how often to distribute it. And I found that they are becoming much more popular amongst folks to use, and it allows for some good decision making in that regard. So I had a family who said, they came to me and they said, well, we want all of our money to be distributed equally to our children, and we would like them to do some charitable giving with their individual inheritance. And I go, but if you're giving it to them, it's theirs. So you can ask them to do that, but there's no requirement of that. So I go, all right, we understand that. And they changed their plan and they said, we want 10% of all of our assets to go to a donor advised fund, with our children being the ones who will advise how that gets distributed out to charities afterwards. So that way they didn't have to ask, they already put it in place, but they wanted to nurture them, the next generation, to learn about charitable giving and doing it in a thoughtful way after their death and distributing these assets that way. And the donor advised fund works perfectly in that situation.
That is great. So I have some specific questions that came through both before and during our talk right now. So I think, okay, should a retirement account with a named beneficiary be put in a trust?
All right, so trusts are tricky with retirement accounts. If you name your revocable living trust, which is the basic trust that most people think about when they create a trust, if that trust doesn't meet certain IRS regulations to be what's called a look-through or a see-through trust, and these IRS regulations are very, very tedious. If it doesn't meet those requirements, then the Secure Act says that you only have 5 years in which to liquidate the account. When you name just a regular old individual, no special concerns, no minors, things like that, and they're not a spouse, they have 10 years in which to liquidate the account when you're just naming a typical individual. So by naming a revocable living trust that doesn't meet these certain IRS regulations, you're going to be shortening the amount of time in which that retirement account has to be liquidated in half, from 10 years down to 5 years. So instead, you can do one of two things. If it needs to be, well, a couple things, 3 things that I can think of off the top of my head. If it needs to be in a trust because the person's a minor, you can create a separate retirement trust for the minor. You can, within the revocable living trust, create sub-trusts that meet these IRS regulations, but you get into some really tricky rules in terms of naming beneficiaries. So it's super complex. And if you name the wrong beneficiary, you lose the whole benefit of that. Or certain other kinds of trusts will qualify for longer periods of time. For example, if you have a special needs child or an adult child who is has certain disabilities, you can put the retirement account into a special needs trust and extend it beyond the 10 years where you're using these required minimum distribution rules. So there are a few exceptions to this 10-year rule that apply to most people, but generally speaking, I would not name just a basic trust as the beneficiary of a retirement account unless you really talk about this with your attorney about the specific IRS regulations, particularly in light of this new Secure Act that was passed last year. It's just a super mine-filled area of law now.
Thank you. What about joint trusts? So someone says, you know, they're domestic partners with two separate trusts. And so does it make sense in their situation or maybe other situations to have a joint trust?
I'm happy to answer that, or Terry, it doesn't matter either way. You know, in terms of whether to have a joint trust or to have separate trusts, if you have a joint trust, you have to really have a lot of faith that the other person that you're making the joint trust with is not going to be making any changes if you die before them. And that's always the risk that comes into play when you have unmarried couples or you have blended families. I always have to have this discussion. Domestic partners who, again, are not married, you want to be talking about what are the implications if one person dies before the other one, as opposed to like a common car accident or something like that. Most trusts will provide that on the death of the first grantor or settlor, that's the person who creates the trust is still revocable or amendable. And that's a good thing usually because the laws can change and you want some flexibility, or circumstances can change, or you don't want to have an inheritance going to someone who is on government benefits because they just got in, you know, an accident and they're now on disability or something. So you could make it irrevocable on the death of the first person, but then you don't have that flexibility. So oftentimes having separate trusts might still be a good thing, but it's really so personal. It depends also on how you hold your assets. I mean, do you have a house that you're owning as joint tenants, where if one dies, the other one automatically gets it? Or are you owning it as tenants in common, where my half goes to my people and your half goes to your people? That's the same thing with accounts. Do you own individual accounts or do you have joint accounts? So there are a lot of factors that can go into just that simple question: do I have a joint trust or do I have separate trust? But it is kind of it is a sticky area to really talk about because of the potential for change after one person dies.
Thank you. So we're coming to getting close to the end, and I just want to have one more question, and it's kind of a wrap-up question in a way, because there's a lot of people that have had a lot of questions that are specific to their circumstances, and we certainly want to recommend that they see their professional. And this question is: to coordinate tax implications for retirement accounts and other variables, who is the best professional to consult?
Yeah.
So I would ask, let me just revise that to who are the best professionals to consult, right?
I think that's a great question, because I think, you know, and I'll speak for the legal area there. I think sometimes we can get our egos in the way and think that we know everything and our lone rangers. And in this area, I suggest that you run fast if you're dealing with a lone ranger there, that you want to make sure that you bring in talent, just like Mara said. And I will also say, I'm not a tax professional. I know enough to be dangerous. And so I'm going to pull in those tax professionals when we're dealing with the specifics of that. Likewise, when I'm dealing with charitable intentions there, I'm not dealing with this every day. I'm dealing with it on an occasional basis, and I'm going to pull in folks like Donna and others there to help support and provide guidance and say, look out for this landmine here or that. And so you want, you know, talented professionals to assist you, and also your financial advisors who are managing your assets for you. And one more step to take with that, especially when we brought about how you can pull money out after a death of retirement plans, is understand what the rules are of a custodian of a retirement plan, because they don't have to do what the IRS allows. Some of them say, look, we don't want to deal with any stretch out over this period of time or what have you. So you want to have a talent pool of accountants, development professionals, financial planners, the attorney, and also make sure you understand who's holding your funds, what their requirements are.
I totally agree, Terry. Thank you so much, Terry and Mara. I'm sorry that we didn't get to all the questions, participants, that we really appreciate our audience, that you were so engaged today. And let me turn it back over to Sally Baker.
Thank you, Donna. And thank you so much, Terry and Mara. We really appreciate your expertise and that you took the time today to share it with us. If we didn't get to your question, please don't hesitate to reach out to the Office of Plan Giving. We're happy to try to help answer those questions. You can also visit our website, plangiving.umich.edu for more information. We want to thank so many participants who joined us today. Thank you very much. We really appreciate your participation and engagement, and go Blue.